We are in a transition period where we have to go into modes of beyond training and education, because the world realizes that it is this opportunity of the current state of affairs which promotes ideation. And ideation is that intangible creation of human intellect, which we call as intellectual property. The law has provisions to safeguard this creation of yours, which has got social implications, personal implications, and definitely financial implications. So that nobody pilferages or copies your idea and starts earning, and you are left in the lurch. This IPR rights provide the ideations, the creations, and the individuals to have safeguards. And that is why, rightfully so, we have invited Mr. Sinha here to give us insights into what an IPR stands for. This event is taking place for the first time in this governmental level, and I appreciate the efforts of my team who have made this happen. Looking forward for this lecture of yours, for this presentation of yours, and I am certain my young students who are almost in an era where we don't look for roti, kapda, or makan. So they have enough time to ideate. And when they ideate, probably the world has a lot for them, and probably they will be able to create a lot more for this mankind. With that, I welcome Mr. Sinha again, and over to you, Tsunami. Thank you.
Thank you, sir, for your kind words. I would now like to introduce everyone to our speaker, Mr. Nirmalya Sinha. Mr. Sinha has done his MTech in Materials Engineering from Jadavpur University, Kolkata, and also completed one-year executive program in bus management from IIM Kolkata in 2006. He has joined Patent Office in the year 2002 as Examiner of Patents and Designs, Group A, Gazette Officer. Presently, he is working as the Joint Controller of Patents and Design and Head of Office in RGNIIPM Nagpur since 2021, which is the Central Government National IPR Training Institute in India. He was deputed twice for training at European Patent Office, Hague, the Netherlands, and at World Intellectual Property Organization, Geneva, Switzerland, on examination and CDIP issues, respectively. He is versed in several foreign languages like French, Spanish, and Russian, and has delivered many lectures on IPR in various parts of the country. Now I call upon Mr. Nirmalya Sinha to start his presentation.
We are really privileged to attend this workshop. Before we proceed to the presentation, I'd like to inform the viewers to leverage this workshop to the fullest, and feel free to drop in your queries in the Q&A box. At the end of the session, a feedback form will be circulated, the submission of which will earn you a certificate from the Government of India. I now call upon our speaker, Mr. Nirmalya Sinha.
Good afternoon to all of you. And it is an immense pleasure to address you all in this August gathering. And I will shortly start my lecture. It is a somewhat related topic which you all may be knowing, because you are all graduates in the field of marine engineering, undergraduates, and also I think other streams are also there. And let me share the presentation. Yeah, is it visible?
Yes, yes, it is.
Yeah. So today we will talk about intellectual property awareness, rights awareness. So this is something in the future you will get to know, because you are already in engineering discipline. So it is something which is very much related to science and technology. So again, you will have to deal with some marine things after you join work when you graduate out from this institute. So at that time, you will get in touch with this intellectual property, and you may have to confiscate some goods in some shores so as to which may be contravening the rights of that particular country. And that is why I am trying to introduce you to the subject matter. So intellectual property rights as such, it is you can see there are diverse scope in this field of intellectual property rights. If you are science graduate, then you can become a patent agent, you can become a patent drafting specialist, or if you are a law graduate, then you can become an expert in trademark and copyright. Even you can become a patent valuers, where you will analyze patents and value patents. And also there are experts called as licensing specialists who look after the licensing of patents. Again, legal process outsourcing is there, where you can be a part of. Again, government IPR office, like you can join as examiner of patents and designs in the government IPR office. So our office is presided, works under the Ministry of Commerce and Industry, that is the Department of Promotion of Industry and Internal Trade. And our head of who is the chief is called the Controller General of Patents, Designs and Trademarks. His office is at Mumbai. There are a number of sister offices which function under him. One of them is the Patent Office, which has 4 branches at the 4 locations in the 4 metros. The Trademarks Registry is in 5 locations in Mumbai, Delhi, Calcutta, Chennai and Ahmedabad. And the Design Wing is in Calcutta. The Geographical Indications Registry is in Chennai. And the Copyrights Office is in Delhi. And the Semiconductor IC Layout Design Registry is in Delhi, whereas the Training Institute is here at Nagpur. So this is how our offices in the 4 locations look like. And they have been built by the NBCC and a few years ago. And this is the International Search Authority and International Preliminary Examination Authority at Delhi. And this is our institute at Nagpur. So ipindia.gov.in, this is our website where you can get to know about the intricacies of patents, designs, trademarks, geographical indications. From time to time, we give the office orders and send you the updates, and also post the relevant programs. We offer many public training programs as well as departmental training programs for in-house training of our staff, as well as we train general public in return of a particular, of a nominal remuneration. And now we are extending this particular training as a result of to celebrate the Azadi Ki Amrit Mahotsav, and which is to celebrate the 75th year of independence. And that is why we are reaching out and to you and giving you some basic ideas about intellectual property right in this 1 year, 1 hour program. This is, however, a free program. So this is how our website looks like. We are there on Facebook as well as on Twitter, social media. And our figures, if we compare with the figures in the earlier 5 years ago from now, then we can see that there is a jump in the number of filing of patent applications that has increased by 1.5 times, whereas the grant of patent applications has increased almost 5 times. So this is also the case in case of trademark as well as in copyright. If you see the figures, you can find it out. So patent applications, if we compare where does India lie, how many patent applications do we receive in India because patent is a benchmark of R&D, which is being carried out in a particular country. So naturally, where China has more an R&D activity, and it receives the as high as 1.5 million patent applications in a year, whereas India receives around 56,770 applications in 2020. And that shows a jump of 6% over the previous year of 2019. So if we compare our figures with that of other countries, we can see that China is quite higher side, whereas India comes 7th, and the bulk of filing relies from non-resident. We receive most of the filing from foreign countries, whereas the smaller share belongs to the domestic filing. So the number of patent examiners employed in our system is at present 600 examiners are almost employed, whereas there are 13,000 examiners in China, followed by 8,000 US and 4,000 in Europe. So this line graph shows you the 1.5 times growth in the filing of patent applications over the period of 6 to 7 years from now and it also shows the 5 times increase in the grant of patent applications, which you can see from the graph. So at present, we are trying to boost the domestic filing. For boosting the domestic filing, we are giving some concessions, like 80% fee concessions we are giving for startups and MSMEs, and 80% fee concession for institutes is also available. Again, for publication fees, also 80% fee concession we are giving. 50% fee concession for design fees, and fees concession for if there is a ladies applicant, then they are eligible to file a fee request for expedited examination, by means of which an examination that will be carried out of turn, and it will be finished almost within a year's time. So this benefit has been given from the side of the by amending the Act and rules, and we have also online filing facilities, so that people sitting in any smaller cities in India can also access these patent offices and can file and upload the documents by online means, and video conferencing facility is available, by means of which you can you can avail video conferencing with the controller who is dealing with your particular patent application, and SMS notification facility is available. We have been able to reduce the pendency in chemical and biotech cases by and large, and we have been able to achieve disposal of design applications by 6 months time, and disposal of patent applications in 1 year time. If filed form again, if you file form 18A, that is the request for expedited examination, which can only be filed by certain, if you fulfill certain conditions. I am coming to those conditions, and request for in form 9, that is the request for early publication. If you file these 2 forms, then you can complete the patent disposal system within a year. You do not have to wait for up to 5 years to dispose for the prosecution of your patent application. Again, refund of examination fees is also available if you seek to withdraw your patent after filing, but before examination has started. Physical filing is also facility is also available, but the fees is 10% higher than online filing. So when do we allow the request for expedited examination? When you file 18A, and that is allowable when you have selected India as one of the countries in the as an international searching authority, and the applicant is a startup, or the applicant is a small entity, or if there are joint applicants, then one of the applicant is female, or the applicant is a department of the government, or a government institute, or it has an international agreement, bilateral agreement with the foreign patent office. Like we have a bilateral agreement with the Japan Patent Office, so they are also eligible to file this request in Form 18 for expedited examination. Recently, we have achieved the benchmark that in the year 2022, our domestic filing has surpassed the foreign filing, which I was showing to you in the earlier slide, that the foreign filing is always higher than the domestic filing. But particularly in this year 2022, our domestic filing has surpassed the foreign filing figures. And so this is a positive sign. It means more and R&D activity are happening in our soil, and that is why we are receiving more patent applications. So I was saying about the different kinds of intellectual property right, which is managed by our department. So out of these rights, there are patents which is managed and by the Patents Act, governed by the Patents Act 1970. The trademarks, any brands, logos, symbols, these are called trademarks. So these are governed by Trademarks Act 99. Copyright, that is given for dramatic work or literary work, that is governed by Copyrights Act 1957. Similarly, geographical, we always come across GI tagged goods. So geographical indication registry is in Chennai, and that is governed by Geographical Indication Act 99. And the Designs Act is 2000. It is governed by Designs Act 2000, and Semiconductor Integrated Circuit Layout Act is governed by the Act of 2000. So intellectual property, if we see, it is somewhat different from the day-to-day what we come across, the movable property or immovable property, which we talk about in day-to-day life. So these immovable property or movable property are called tangible properties. They are called tangible properties because they are exactly measurable. But intellectual property cannot be measured exactly, so it is called intangible property. The intellectual property has to be can be further classified into industrial property and copyrights. Industrial property again can be classified into patents, designs, trademarks, and geographical indications. So this is a type of property, intellectual property, I mean to say. It is somewhat a property which is where you can execute agreements, just like tangible properties, immovable or immovable properties, but you cannot exactly fix the value. Although there are valuers, but still you cannot exactly estimate the value of the intellectual property. That is why it is called intangible property. So intellectual property means giving shape to your creative ideas and expressions of the human mind. You are giving your intellect, giving shape to your intellect. So, and what you are doing by that, you are harnessing, you are commercially exploiting that idea or expression which of your human mind. So you are commercially exploiting that idea. So by that means you are creating the intellectual property. So it is a type of asset. It is a type of asset. Now, when you proceed for intellectual property registration, we say that you fully disclose your property. In return, we will give you a monopoly right. So that is called a patent. And that patent right is valid for a period of 20 years. So we say that yes, we will give you a monopoly right of 20 years. You can make, exercise, you can use, you can sell, you can distribute, you can authorize somebody else, you can license. So you can do all these things, but only you can do. You can exclude others from doing it because you are the owner of the patent right. You have only the monopoly right to do it, to market it for a period of 20 years. After the period of 20 years, your monopoly right ceases and it becomes a public property. So what you can do with your asset, you can buy it. Asset means here intellectual property. You can buy the intellectual property, you can sell the intellectual property, or you can license it, or you can exchange the intellectual property like any other form of property. So intellectual property avoids duplication of research. So why do we go for intellectual property registration? So that we do not want to waste our time and energy for what is already done. That is why we avoid, in order to avoid duplication of research, we do intellectual property registration. Similarly, utilizing the published patent journals, we want to utilize because every time a patent application is filed, we have to wait for 18 months and then it will be published in the official journal. Now, if you don't want to wait for 18 months, you have to file Form 9 for early publication. In that case, within 1 month of filing of Form 9, your application will be published. And this is called early publication. So you get to know a vast amount of data is available in this patent office journal, and you should go through the patent office journal in order to stay acquainted with or updated with the latest developments in science and technology. So again, I said you that this is a monopoly right which lasts for a term of 20 years, and after the 20 years it ceases, the monopoly right ceases and it becomes a public property. So you cannot no more have the exclusive right to market or make or sell or distribute your invention. Nobody needs to take your permission after the expiry of this 20 years. This 20 years starts from the date of filing of your patent application. That is why we say when you have an invention with you, the first thing you do is to file a patent application. It has a very nominal fees of rupees 1,600, so that you file it, and you from that day your count starts. Your monopoly right, you start to enjoy the monopoly right as soon as your patent application gets published. So serves as an indicator of achievement in institutions and R&D. So this research and development, it serves as an indicator of the amount of effort or energy you have put into research and development. Similarly, it is an exclusive right for to make, use, sell, exercise, or distribute your invention, and this right can be shared, licensed, or sold. So it is an encouragement for improvement of technology. So why do we give this monopoly right? We give this monopoly right because we want to encourage you to come up with more inventions, so that for the benefit of the society. The only thing you have to do is you have to be ready with your invention. You have to make a drafting of your invention. You have to draft the description. You have to draft the drawings, and then you have to file at the patent office. If it is at your invention is at a preliminary stage, then you file the provisional application. If your invention has received finality, reached finality, then you have to file the complete specification. So along with the complete specification, you file a body of claims, and then in this way, you have your disclosure should be enabling disclosure, by means of which you disclose your patent application and you say what is your invention. In return, we examine your patent application and then we grant it to your patent. So what you can do is you can earn profits or royalty through putting the invention into practice, or technology transfer or licensing, and you can commercially exploit, because every time you come up with a new invention, you have a fear of copying or imitating. So it can be copied or imitated by unscrupulous persons. In order to prevent that, you go for intellectual property registration. That is, you go to the patent office for the registration of your patent. You go to the trademark registry for registration of your trademark. so that your brand or symbol is registered and no unscrupulous person can copy it or imitate it without your authorization. If they do, then you can slap a notice and you can draw him to the court of law. Then once your application, trademark application or patent application has been published in the journal. So production competitors from copying or imitating. You can prevent others from copying or imitating your product, and you can by launching new brand name or new logo into the market, you can expand the market share and you can venture into new markets or business. You can increase the valuation of your company and the brand value. You can increase by launching your trademark into the market, because you know as soon as you launch the trademark there is a brand or a logo or a symbol which you launch for when you launch a particular good into the market, you use it, and at that time that particular trademark comes into being. Your right automatically comes into being. But the reason you have to approach a trademark registry is so as to have a trademark registration in your hand, so as to have some certificate in your hand, because that certificate will provide you with evidentiary value and will protect you from any undue infringement by unscrupulous persons. So creating a corporate identity through trademark. Negotiating. So you can negotiate license and franchise, IP-based contractual agreements, and just like agreements you do with movable or immovable property, in the same way you can execute agreements with intellectual property like trademarks and patents. You can franchise your brand to interested parties if it has already earned a sufficient amount of goodwill in the market. Again, once it has been published in the trademark registry or it has been published in the patent office journal, you can initiate legal proceedings, because you will start to enjoy the right as if it has been granted once it has been published in the journal. So you can initiate legal proceedings against infringement of patent or trademark. So these are the different types of property which are at present being handled by our department. Patents is related to technology, and technology, it requires the three requirements are that novelty, inventive step, and industrial applicability. So these are the three requirements of an invention which has to be satisfied if you want to get a patent. The another condition which you require is non-patentability. Your patent should not fall within that non-patentable clause. Otherwise, there are many inventions which may be inventions, but they are non-patentable. So your invention should not fall within the purview of non-patentability. So patent is given for a period of 20 years. Designs is given for a period of 10 years. Design is also an exclusive right by virtue of which you register that unique shape or external appearance of the object, which is the design, the color or the texture, everything you can be registered. The only requirement of design is that novelty. That means it has to be new. Suppose two designs are pre-existing and somebody has combined both of them, two of them, and has brought out the third design. Now this is not satisfying the novelty requirement. So novelty means no combination of prior designs is allowed, and no individually as well as in combination. It should not be allowed. So design, the only requirement is the novelty, and it is given for a period of 10 years and extendable by a period of further 5 years. So word, logo, and slogan, these are given for trademarks. So make a logo or brand to distinguish the goods from others. So why do we launch a logo or a brand? In order to distinguish the good of one trader from that of other trader. So at times the custom authorities can direct you that please do not, you will be you will be directed to confiscate the goods of a particular trader because it is infringing somebody else's trademark. It may be that, it can occur in future. So you have to know that what is behind this. The principle behind this is trademark registration, because he has infringed another's trademark. So another's right he has infringed, and that is why he has been penalized and his goods are being confiscated in the port or somewhere else. Onshore, generally, this type of thing occurs. Again, trademark is given for a period of 10 years, and all these rights, patents, designs, and trademark, these are all territorial rights. They are country-specific rights. So if it is India, so it is only exercised in the borders of India, in the shores of India, in the ports of India. So it is only exercisable. If you leave the country, you cannot exercise it. Similarly, copyright is given for literary work, dramatic work, or musical work and paintings, artistic works, architectural plans, and software codes. So lifetime, it lies for the lifetime of the author plus 60 years after his death. So GI tag, I said that you may come across many GI tag goods which sell good in the international or national market, because the GI tag is sought by a group of businessmen or traders, cluster of traders who deal with a particular product. Suppose Nagpur oranges, Darjeeling tea, Sambal Puri sari, these are all GI tagged products. So Dokra art of Madhya Pradesh, Bastar, MP, these are all GI tag products. So these are valid for a period of 10 years and it can be renewed every 10 years. GI tag is given because of the unique property of the substance by virtue of belonging to that particular place, by virtue of originating from that particular place. That is why the GI tag is given for a particular object. So the cluster of traders generally they only apply for GI tag. A single product can have multiple intellectual property associated with it. Suppose a laptop or notebook which is launched into the market can have patent right associated with the constructional feature of the processor. The processor is patent protected. Intel Pentium core processor, that is patent protected for a period of 20 years from the date of filing of that particular patent application. So design is the external design which is very good looking or sleek, which is aesthetic, beautiful, and it is appealing to the user and it is appealing to the customer. So that design is also registered in the designs registry. Trademark or the brand or logo by which the product is known to in the market to the common user, that is also trademark registered in the trademarks registry. A copyright manual which comes bundled along with the product, it contains many information. The user operation manual, it will say how to use and what will happen if anything goes wrong. So these things are all protected by copyright. This manual is the information there so that no one can copy it. So when a product is launched in the market, multiple intellectual property is associated with that product has to be taken care of by the IP department of that particular company. Now, if you go for elementary searches regarding some elementary objects which is very much used in day-to-day life, like ballpoint pen. So if you go to use a search for a ballpoint pen, you can see it was patented in the US Patent Office on 1939 and about almost 90 years ago from now. So this is the case where the ballpoint pen was invented, and at that time, what did the gentleman do? He modified the pen tip and used the ink that dried quickly and did not smudge. So he made some modifications which proved to be inventive, which proved to be very much practical and useful for the general public. So so the pen now could be written on paper. Previously, it could only be written on wood and leather, and so it proved to be very effective. So that is why how you come across invention, and that is why how you protect the invention by filing the patent. If you feel that your invention has the capacity to get a patent. So if you search for ballpoint pens, you will get a list of publications in the Google patents, patents.google.com. Similarly, paperclip. If you go and search, you will get these publications for paperclip. Similarly, needles, you can get these things. And if you see, you are all acquainted with this car, which was launched by Tata a few some 5 to 10 years ago. It had 37 patent filed, 37 patent applications for that particular car, and 31 design applications in the design registry. So mechanical tree climber. So tree climber is also patented. It is used for scaling palm and coconut trees. It is a recent development which is patented. Similarly, a cane has been designed by IIT Delhi people, which is for visually impaired persons to detect obstructions at the distance of, from a distance of 3 meters. So what do you need to become an inventor? The need is to, if you want to become an inventor, then you have to identify a need or problem. You have to identify an idea or inspiration for something new. Then you have to see that whether you are searching for something or your idea which you have brought out that is better than what is existing in the market. So already existing in the market, you have identified a need or problem and thought of an idea. Then you jot down the points. You start experimenting and adjust your invention until it works properly. Remember to keep notes with description and drawings of your experiments of your invention. So you have to jot down the points. You have to jot down the description and drawings so that you file if it is a patent eligible matter, then you can file for the patent and get a patent. Because in patent office, we do not require any prototype or model to be submitted. Only you need to give a written description along with drawings of your invention. But that description has to be full and sufficient. So Patents Act 2005 and Patents Rules 2021 are the governing act and rules which. So the patent is a monopoly right, as I said you, it is an exclusive right. We often see that the patent rights are being infringed by some other parties, and that time you can slap a notice in the newspaper, or you can approach the court of law and that so and so unscrupulous person is trying to copy your product or imitate your product, and you have incurred losses in the order of crores or in the order of lakhs, and you can claim that particular amount from that particular person. And so this is an exclusive or monopoly right which is given by the government. It is limited to the area of the country. It is valid only within the territorial limits of the country, and it is only valid for 20 years from the date of filing of your patent application. Oh, yeah, and in return, what you do is in consideration of full disclosure of your invention. You you get the monopoly right. So we always say that do not publish your invention first. If you have a patent eligible matter, first file the patent. The fees is nominal of 1600 rupees if you are going for online filing, and it is physical filing is 10% more. And the only thing is that if you publish, then you will lose the novelty, and your novelty right will be forfeited, and because your publication will serve as a prior art, and when our examiners who are who will examine your patent application, they will search for prior art, and when they find that you have already published it, then they will say that it is no more an invention because it is no more new, because you have already published it before filing the patent application. That is why we always discourage from publication before filing of patent, and we always advise that you please file a patent and then only go for publication. And model or prototype, if you have, then it is not required by the office. Only what we require is the written description, drawings, and claims. So how patent rights can be lost? It can be lost due to premature disclosure. It can be lost due to, just as I said you, that if you publish it before filing a patent, then it can be lost. That is called premature disclosure. And if you have any employees disputes over IPR, any dispute with your employer over intellectual property right issue over the particular invention, over the invention, over how to share your royalty or some other aspects, and then you may have a problem with the patent right recognition, and then sometimes you do not recognize your contribution adequately, and that is why you failure to recognize invention that takes place, or it may be some loopholes may be there in the joint development agreements, due to which intellectual property right areas may not be taken care of, and that is has to be addressed satisfactorily, and that is why you should be careful to address these intellectual property right issues. Now, we often call something which is utility model to workshop innovation. So you often our small scale industries or micro enterprises, they come up with these type of inventions which are called minor inventions. They are minor inventions because they may be new, but they are not so much inventive. That inventive step may be lacking. So, but they are industrially applicable. They are very much practical and they are very much applicable. So it is our India is in process of giving a utility model in the process of framing an act for utility models, and lower level of inventive step, and the procedures have simpler procedures and offer shorter term of protection. Or though at present we do not offer any protection for utility models, but in the long run, maybe after the act comes into place, the Utility Model Protection Act, then these minor inventions will be recognized, and some 7 to 10 years protection will be given for them. So at present, countries like Germany, Japan, and China, Korea, they have this utility model protection, and they give protection to these minor inventions even. So we do not give patent for discoveries, such as there are many elements in the chemical periodic table which you may be knowing. So these metals and non-metals which are there in the periodic table, they have all come out, or they have all been isolated or by means of some experiments, but they were already existing in nature. So none of it is an invention. So they are all discoveries. So discovery has no technical effects. And for discovery, you cannot give you a patent. In the patent office, always tries to limit your invention, means try to determine whether it is a discovery or it is an invention. If it is an invention, then your effort will be recognized. If it is a discovery, we will not give anything. So it is comes under section 2(1)(j) of the Act. And the requirements of invention and newness, inventive step, and capable of industrial applicability. Inventive step means it has to be non-obvious. So I said for utility model, inventive step need not be there. It may be obvious, but novelty or newness has to be there and industrial applicability has to be there. So invention means a product, a process, apparatus, device, process, method, which is new or having inventive step or capable of industrial application. So novel or new is when we say that an invention is new, we say when it has no prior art. If it has not been disclosed in any prior art, then we say, what is a prior art? Prior art is anything which has been published or presented or exhibited before general public before the date of filing of patent application. So that is why we search for prior art, and we search in the prior art, and we have to see. One is the question I have received: what is the difference between provisional and approved patent? So see, when you file, when your invention has not reached finality, then you file a provisional patent application. Then the moment you file your patent application, your priority date starts from that period. But the approved is after that particular patent application has been granted, has been examined, and we have sent a first examination report to you. You have replied back to that examination report and complied with all the requirements of the examination report, and then only we grant that particular patent, and after grant it becomes an approved patent. So this is the difference. Another, can we patent a software instead of copyright? So we can, I'm taking a few questions now. We can patent a software provided, I'm coming to that, it has a technical effect. If it is only a computer program per se, if the output of the product is only a number, then we do not give a patent to that software. Then we say that it is only a computer program per se, and it comes under section 3K, which is a non-patentable subject matter. So I am coming to more questions later, and everything that has been published, presented, or otherwise disclosed. So in this way, prior art is something which has been published. So we search for prior art. The examiners, our examiners search for prior art for all the patent applications which has been filed with the prior patent office when they take it up for examination. So for inventive step, we try to judge the technical advancement. We try to judge the economic significance. We try to judge the what makes the invention not obvious to a person skilled in the art. So it should not be obvious to a person skilled in the art. This we have to see. This we have to ensure. If it is lacking in inventive step, if it is obvious, then it is not fulfilling a criteria of the invention, because for invention you have to satisfy all the three criteria: novelty, inventive step, and industrial applicability. And then only it can proceed for patent. So some indications of non-obviousness are a surprising result, the solution to a long-standing problem, and the fulfillment of a long-felt need, and a great technical progress. So these are the indications of non-obviousness which need to be determined by the examiner. After reading your patent application, we come to the conclusion that whether your application is lacking in inventive step or not. Another thing is industrial applicability. Industrial applicability means your patent application should be practical. It should not be abstract. It should not be theoretical. It should not be only limited to theory. It should say something which should be, it should disclose something which should be an enabling disclosure. So only then it will be industrially applicable. Similarly, unity of invention, one single application should contain only one invention, and it should be for a product or process. So for filing patent application in India, we see that whether it is an invention, we see whether section 21J has been satisfied, that is novelty, inventive step, and industrial applicability. The next we see that section 3 and section 4 are also do not fall under section 3 or section 4 because they are the non-patentable sections. So next we come to non-patentable inventions. So non-patentable inventions are some inventions which are frivolous inventions. Inventions contrary to well-established natural laws machine, like a machine giving 100% perform more than 100% performance. So this is not possible practically. So this is which is defined the laws of physics. So these are all called frivolous inventions. They are not patentable under section 3A. Similarly, for public order or morality contrary to public order, which causes serious prejudice to human or plant or animal health or to the environment, like weapons of mass destruction and device for housebreaking and device for gambling machine and method of adulteration of food, these are all non-patentable subject matter under section 3B. 3C says that any scientific principle is non-patentable. So any Archimedes principle or Newton laws are not patentable. But if you make a practical application out of that thing, practically you show some technical effect and which has novelty, inventive step, and industrial applicability, then you are eligible to get a patent. Then 3D says that mere discovery of a new form or known substance which does not result in the enhancement of known efficacy of that substance is not patentable. So if it is a beta crystalline form of a drug which does not show any significant efficacy, then therapeutic efficacy, as you may be knowing from the famous court judgment of Novartis versus Government of India, where the Swiss drug maker Novartis was turned down. The drug Glivec was rejected by the patent office, and the Supreme Court also upheld the decision of the controller and rejected that and refused to give a patent to the Novartis. So at that time, it was on this section 3B, the whole judgment was based upon that enhancement of known efficacy. Similarly, if it is an admixture, then section 3E says that if it is an admixture, then it is obvious that the component, the admixture will be the combination of the properties of the components. But aggregation, if it is a synergistic mixture, then and only then it is patentable. Composition of two drugs like paracetamol and brufen, antipyretic, and one is analgesic. So you make a new drug and which is both antipyretic and analgesic. This is very obvious. So this is not allowable, not patentable under section 3E. Similarly, under section 3F, if arrangement or rearrangement or duplication of known devices, each functioning independently of one another in a known way, if there is like a bucket fitted with a torch, umbrella with a fan, clock and radio in a single cabinet, they are not patentable under section 3F. 3H, method of agriculture or horticulture is not patentable. The method of producing a plant, method of producing improved soil by giving treatment, method of producing mushrooms, method for cultivation of algae. However, agricultural equipments are patentable. So section 3I says the diagnostic method, medicinal method, surgical method, prophylactic method, like method of vaccination, surgical method, method of cataract removal. So these are all not patentable. Again, method, however, manufacture of artificial limbs or prosthetic limbs are patentable. Plants and animals fall under the Plants, Varieties and Farmers' Right Act, which comes under the Ministry of Agriculture, and they are the Protection of Plant Varieties and Farmers' Right Act 2002, and so it is a non-patentable subject matter. Once someone asked that it is whether it is related to computer programming can be patented. So under this section 3K, computer program per se means as it is not patentable. But if you are showing a technical effect, then it is, or a technical advancement, then it is patentable. By technical effect or technical advancement, we mean to say that the output of the computer program should not be only a number. It should have some technical effect, which is technical contribution to the prior art, which was not shown and which was not known hitherto by persons skilled in the art. So only then it will qualify as a patent. Otherwise, it will be treated as computer program per se. There is a court case judgment of IPAB, Intellectual Property Appellate Board, which says that this technical advancement is necessary for judging a computer program applicable per se or not. Similarly, business method are not patentable. Business method means to say, which is very evident, obvious, and only you have done some automation, which is very obvious from the point of view of the advancement of technology around us. So this is not patentable. Business method patents, like UK Patent Office had refused an application to an Australian gentleman who wanted to automize the documents of filing to incorporate a company. Similarly, mathematical method is also non-patentable, but if there is a theoretical technical contribution to it, then it is of course patentable. Like if you can shoot a trajectory and you can launch a satellite into an orbit by virtue of a mathematical formula, then it is a patentable subject matter as held by the US Court of Appeals. Similarly, literary work, dramatic work, or musical work, or artistic work, these are the work which are created by fall under the purview of copyright, and so they are non-patentable. Mere scheme or rule or method of performing mental act, or method of playing game, like method of teaching, method of playing chess, method of learning a language, method of solving a crossword puzzle, is a non-patentable subject matter, and it falls under section 3M because it is a method of performing a mental act or playing a game. Similarly, if anything belongs to traditional knowledge, like time and again, many companies have eagerly wanted to file monopoly right for substances like neem and basmati, neem and turmeric, medicinal properties. They wanted to exploit it, but these are all well known to us from Ayurveda or from Veda or Vedic texts or from Unani literature. And so these are all part of a traditional knowledge which we have got from our heritage or from our generations. So these are all being drafted as traditional knowledge digital library. Traditional knowledge digital library and the traditional which is called TKDL. So TKDL database has been formulated by the government so that the foreign multinationals do not seek to patent monopoly right on substances which are product of our heritage or which have been which are product of our traditional knowledge like neem and turmeric and their medicinal properties. So all substances related to atomic energy are also not patentable under Section 4 of the Act. And I think my time is over and you can ask some questions. So there are some questions which I can see in the question and answers. Sir, can a patent be applicable which is registered in one country is applicable? See, a patent is an absolute right. It is only applicable in the country specific to where it is, where you have filed the patent application. Suppose you have filed in Indian Patent Office, then it is only applicable. Yeah, and you have got Indian patent, then it is only applicable within India. It is not applicable in other countries. But it is your novelty will be maintained, because novelty is an absolute requirement. So no one else can copy it throughout the world. That is because we are signatory to the multinational agreement like PCT and the Paris Convention. That is why we give same benefit to others, and we also give the protection to others. But it is only applicable in your country. It is not applicable in foreign countries. Can a conceptual design model be patented? Conceptual design model cannot be patented, but it can be design registered. Do we require to file a register or patent in every country? Yes, for registration or patent, you have to file in every country by means of the patent PCT route, international filing route. There is a particular way where you can file. And if you want to know more about this, you have to enroll for our paid courses, which we run from time to time. We offer from time to time. You can get the detail of our paid courses from our website, ipindia.gov.in. And in remuneration of for 1 week courses are charged of almost online courses of 2,500 rupees. However, if they are offline programs, then we only charge rupees 5,000. For patent violation, civil procedure code, because this is a civil right, civil procedure code is applicable. The costing here available for country. Please let us know the costing for patent violation is CRPC or CPC applicable. CPC is applicable. Please let us know the costing for a country-wise registration of a patent. Approximately for these, you have to enroll for our detailed and courses, and they are advertised in our website. You have to enroll for that. Can we contribute to TKBL? For more minor inventions, do we apply using the utility model? Is it available? No, utility model system is not available in India till now, but it will be shortly available as the government is in the process of framing the act. So what is the process for patent violation legal action to be taken in another country where the third party has violated patent IPR? Is it under the jurisdiction of that country or any provision in International Court of Justice? For patent violation, you have to bring the matter to the local court where it has been violated. Suppose you have to bring the matter to your local court. Suppose your patent has been violated, so you bring the matter to it. What is the precaution to be taken while having MOU with the organization for patent royalty distribution? These are the job of patent licensing, and I am not a master of them. MOU, executing MOU, and do we require to file? I have answered this question, and yeah, can you see the screen? Excuse me, can you see the?
Yes, sir. Yes, sir.
Yes, sir.
Yes, sir, we can.
Yeah, can you answer these questions? Which type of IP protects the paintings painted by artists? Can anyone answer?
Excuse me, sir.
Which type of IP protects the painting painted by artists?
Excuse me, sir.
Yeah,
Here that attendees can't answer or they can't talk in this webinar.
okay, they cannot.
Okay. No, they attend. If there are any questions, they can ask the questions in that session Q&A.
Okay,
So
okay,
they are not able to answer that.
okay, okay. Then, Mr. Is it Mr. Sachin?
Yeah, I'm sorry.
Yeah, yeah. So I am done with my presentation, and you can conclude the session if everything is okay, or you can say some queries if you have.
Okay, Tsunami, over to you.
Thank you, sir. That was indeed a wonderful presentation. I would once again like to remind you all to fill up the feedback form, the link of which has been circulated in the chat box. I now request Captain Manoj Hirkane to deliver the vote of thanks.
Thank you, Cadet Mehta. Ladies and gentlemen, boys and girls, a very good evening to each one of you. We all have noted the achievements of Mr. Nirmalya Sinha, who has all possible knowledge and experience about the IPR and patenting. A lecture conducted by a person of this high stature for TMI faculty and students is something noteworthy. On behalf of TMI management, faculty, and students community, I express my sincere gratitude and thank Mr. Nirmalya Sinha for taking out time from his very hectic schedule and delivering this wonderful lecture to us. Thank you very much, sir. Listening to you was a pleasure, and I'm sure my faculty colleagues and cadets have made a note of all important points about how to protect their intellectual property, as well as how to go about patenting. Thank you, sir. Thank you very much.
Thank you.
I also want to thank Professor Chetan Sharma, Professor Sachin Ilag, Professor Rahul Kale, Cadet Tsunami Kotian, and Cadet Mehta for organizing this webinar. And thanks to all other faculty members and students for attending this webinar. Thank you all, and have a great day. Thank you.
One more thing, I will request all the participants to fill up the feedback form, because only then we can, all those who will fill up, they only will get the certificates. Thank you.
Okay, sir. Yes, sir. Thank you, sir. We'll end the session. Thank you so much.